am conveying the message of the nude female body. And if I am clothed, then it's not the same message at all.
How does the message change?
I don't know. It's hard to explain. It's really hard to explain.
We like to make our work out of text that gives us some interesting problems to solve. Text that comes directly from real people speaking has a kind of quality that I think you're often going for in any kind of text that you perform on stage. You want it to have this kind of authenticity, and you get that when you take on something that was just transcribed from speech.
Mr. Chief Justice, may it please the court.
In the case of Arguendo, we're making a play out of the transcript of a Supreme Court oral argument from a Supreme Court case from 1991. The case is called Barnes versus Glenn Theater, and the issue in the case is the First Amendment.
Mr. Ennis, nobody is stopping her from dancing. Suppose you win this point. Dancing is expression. They have not stopped her from dancing.
It's a case in which a group of exotic dancers brought suit against the state of Indiana. The state of Indiana has a law regulating whether or not you can be nude in public. So these dancers who wanted to dance naked were being told they had to wear pasties and G-strings or else be shut down.
Do you feel the message would be reduced somewhat if you had to wear pasties and a G-string?
Yes.
Well, why is that?
How?
Because I'm not conveying the message that I have pasties and a G-string. I am conveying the message of the nude female body.
And so they took their case to court, and it made it all the way to the Supreme Court since it was a First Amendment question. It becomes a conversation right away about high art versus low art. The justices try to sort out what the actual definition of dance is.
Well, what is performance dance? What is it?
What is performance dance is a question in this case.
Whether or not this counts as dance, does it deserve First Amendment protection? And part of the reason that the case is at the court to begin with is because it's a difficult question.
Would one have to analyze the Indiana murder law as valid or invalid under the First Amendment if the murder happens to be performed in the course of a public performance dance?
We don't take the texts that we have and rewrite them into plays. We take the texts and try to present them on stage. And then the kind of conversation between the text and the form can happen on its own in some ways, and create a kind of collision between that form and our form, which is live theater. We work on a kind of faith that when you throw things together and shake them up in some way, they will start to talk to each other. So we don't want to try to invent ahead of time the things they're going to say to each other. We really just want to find things. It's as if we've kind of thrown everything up in the air, all the words, all the people, and let it all land in a different place, in a different kind of constellation.